Hi, everyone. Thank you for coming. It's so funny. I'm just like, I threw my kids on the iPads. My husband's on a work call in the other room. We're sort of making do just like everybody else. So I'm hoping nobody runs into the room during the middle of this, but if so, you'll get to meet my beautiful daughters. Um, Hi, Megan. I'm just looking on the chat. I'm gonna wait a few minutes before we dive into the substance because there's always some stragglers in the first 5 minutes of the session. So we'll give people a little bit of time to show up. My hope is that this is useful, informative information, also really fun. I've tried super hard to stay out of going too far into the weeds because all of the regulations and laws and new rules, everything being passed, there's so many little complications about every single thing. This applies to, it depends on the size of the employer, it depends how long you've worked there, dollars and cents amounts, everything's really particular. So I sort of thought it would be more helpful to just kind of do the best job I can, making this overview really broad, and then pointing you towards all of the resources that have more specific details, as well as offering up for you to call us, call us or email us if you have any questions about your own particular issues, because we're super happy to help. Can anyone I check on your screen? You can see there's an option to send me a chat message. Can anybody message me if you have? Yes, we will give you all of our contact information. Can anybody message me if you have kids that are overhearing and you don't want me to curse? Because I usually curse not a ton, but here and there, and I won't if anyone has kids that are overhearing. All right, nothing yet. I'll ask again. Okay, I hear curse it up, curse away. My 3-year-old doesn't care if you curse. Okay. Oh my goodness. I'm gonna have to keep my eye away from this chat thing. I'm gonna turn it off. All right. Laura, can you just on the presenter chat tell me if anything I need to see shows up? Because otherwise I'll get too distracted with all of the incoming messages. And I need to give a huge shout out to Laura, who was having a heart attack because I sort of put the preparation, a lot of it was super last minute. And that's because every single day, more guidance is coming out. The DOL is issuing, frequently asked questions and guidelines. The latest bucket of legislation was just passed last Friday. So everyone's still kind of reading it, interpreting it, trying to figure out what's going on. And I count myself among that group. So I'm going to do my best to share with you my understanding of everything. But for all we know, tomorrow we'll get new guidance that tells us something different. So let's stay in touch, and I'll keep you posted. All right, it's 2:06. Let's dive in. Okay, pulling up my PowerPoint. I thought that would work. Okay, if Laura can share the PowerPoint, that would be helpful. Awesome. Okay, this is just my sort of introductory slide that you can peruse while I'm introducing myself and telling you a little bit about myself and my firm. My name is Susan Crumiller. I am the founder of Crumiller PC. We are the feminist litigation firm. We represent employees primarily fighting gender and pregnancy discrimination in the workplace, but we're also super proud to represent employees in matters of race discrimination, age discrimination, disability, regular severance negotiations. We also represent people who have faced sexual harassment and or assault in the outside of the employment context. So we have cases against hospitals, other healthcare providers, and individuals here and there. So as we sort of hastily shut down our offices and moved home, we do have the capacity at this moment to provide pro bono services to first responders and to provide free legal advice for people who are seeking assistance in these crazy times. So that's what I'm today is sort of step one of that initiative. I wanted to start by reading you this quote from Brene Brown. Our job is not to deny the story, but to defy the ending, to rise strong, recognize our story, and rumble with the truth until we get to a place where we think, yes, this is what happened, and I will choose how the story ends. I won't pretend that shit doesn't totally suck. I have people close to me who are developing health problems. I'm scared shitless. A lot of people are concerned for your financial stability, your jobs, and the best thing that we can do right now in order to present our best self for our families, be as safe as we can for our families, is to look out for our health and our money. And so my goal for today is to try to help you feel that you're in a situation with respect to your employment where you can protect your health, where you cannot go into a dangerous situation, where you can feel a sense of stability and security with respect to whatever your circumstances are, whether your workplace has shut down, whether you don't know what's happening, if you have fear for your own health issues, partner's health issues, kids, that you can feel a little bit more grounded, a little bit more certain about what the various options are. And of course, more importantly, go out there and get whatever benefits are available to you, whether that's sick leave or unemployment. We all owe that to ourselves, and especially in this time of, it's sort of a war against the virus and against our fucking genocidal maniac president who's trying to screw us over. Okay. So today we're going to be talking about what to do if you get laid off permanently or temporarily, you get sick, you're a caregiver, you or a loved one is immunocompromised or has other sort of particular health issues that you're concerned about, you're made to keep coming in, or you're being discriminated against. That's kind of our basic overview. And then I also threw in some information at the end. We have a quick slide at the end regarding for small business owners, self-employed contractors, etc. But actually, by popular demand, we're going to be doing another webinar just for those folks on Friday at 2. So I have a super quick intro to those issues for today. But if you are an independent contractor, or if you're a small business owner or self-employed, you should stick around for today, but you should also come back on Friday. And I have some other little miscellaneous helpful information here and there too. Okay, what to do if you get laid off permanently or temporarily. Temporarily laid off, furlough, those are pretty much interchangeable terms. So if you work somewhere that's shut down, if your boss is, if your company is doing temporary layoffs, furloughs, you should first of all apply for unemployment. That's the main big takeaway. If you remember nothing else from this presentation, remember that you should apply for unemployment if you're laid off permanently or temporarily. Super common question. Was my boss allowed to do this? Was my company allowed to lay me off? The answer is probably yes. New York is an at-will state. You can be laid off for any reason other than if the reasons are discriminatory. If you're a member of a protected class, they can't lay off all the Black people. They can't lay off all the moms. They can't lay off only people with disabilities. So if you are in any sort of situation like that, call us, we'll evaluate it. But in general, unless there's some sort of flagrant, or not flagrant, but if you're laid off because of the coronavirus, if your hours are cut because of the coronavirus, if your salary is cut because of the coronavirus, the vast majority of cases, that is legal. Even if you have what you think is a contract, usually there's provisions in there saying none of this is really a contract because we're an at-will state, and so we can do whatever we want. And that's just how it is. So if you're laid off, you should apply for unemployment. There's new federal regulations that expand unemployment benefits. So you can now get, in addition to usually the cap is around 500 a week, and now there's an additional 600 a week for 4 months. They're also expanded the time period that these benefits are available for an additional 13 weeks. So it's now up to 500 a week for 39 weeks, plus 600 for the first 4 months. So for 4 months, you can get 1,100 a week, and for the rest of the time, you can get your 500 a week. Now, unlike previously, freelancers, contractors, self-employed, you are all eligible. So you can, no matter what, the extra 600 a week has nothing to do with your income, unlike regular benefits, which are dependent on your income. There's also a waiver of two standard requirements. There's no longer a waiting period to apply for and get your benefits. And there's also no longer a requirement that you continually certify that you're actively looking for employment. Right now, everyone understands like the jobs just aren't out there. And in terms of freelancers, contractors, self-employed, if you are experiencing a decrease in your business because of coronavirus, that's all you need to show. It's a matter of whether I had the income, I don't have the income anymore. Yes, furlough is the same as temporarily laid off. Slides will be available. Okay, what to do if you get sick. So this is the part that, yes, up to $500 depends on income. If you get sick, this is where the very complex and complicated different schemes come into play that I was like, I don't really know how to stay out of the weeds with this. I'm going to do my best. We have the FFCRA, the Families First Coronavirus Response Act. We have the Emergency Paid Sick Leave Act, EPSLA. We have the Family and Medical Leave Expansion Act, EFMLEA. And those are part of the CARES Act. So there's all these different acts, and this is what everyone's talking about. There's guides out there that are way better than my guide. All of these are on our COVID resources page, crowmiller.com/COVID. It's at the bottom of each slide, especially A Better Balance and the Gender Equality Law Center, to feminist-y organizations that are very much on the ground and have A Better Balance in particular always puts out really beautiful fact sheets that I've been sort of scrutinizing as I prepare for this and just in general. The gist of it, with the new federal laws, employers of 500 people are exempt, and that's because we live in a plutocracy. I cannot think of any other good reason. And employers that are smaller than 50, I put are exempt, sort of, because these employers can apply for an exemption that if this would be an undue hardship, but we're still waiting for guidance as to what that means exactly and how those applications are going to be granted. So for now, big question mark, as with a lot of this stuff. So old FEMLA or regular FEMLA entitles you to 12 weeks unpaid. If you have 50 or more employees, you can still get this. But like, who cares about unpaid leave? That's even worse than a furlough, because if you're laid off, you can get unemployment. So unpaid leave, in my opinion, is of absolutely no help to anybody when we're all trying to make ends and trying to keep our income as steady as we can. So the new laws give you 2 weeks of sick pay, which is if you're sick or caregiving. And these include if you're quarantined, advised to quarantine by a doctor, experiencing symptoms and seeking a diagnosis, caring for a family member advised to quarantine, or caring for your child, oops, I found a typo, because your school was closed or daycare unavailable. And this includes your own, there's different amounts you can get depending on whether you're caring for yourself or whether you're a caregiver. So it's like the first three is yourself, and then the second three is caregiving. So if it's yourself, this is up to $511 per day. Caregiver up to around $200 a day. That might not be the exact amount because I like to round. We also have public health emergency leave, which gives you 10 days unpaid. Again, to me, that's tantamount to nothing. Who cares? Unpaid leave doesn't help us at all, especially when so many employers are cutting back and laying people off, whether permanently or temporarily. But it's there if you need it, if you're sick. The good news about all of this is that your job is protected basically. If you have 25 or fewer employees and they were going to lay you off anyway, then this isn't a magic amulet against that. But you're protected against retaliation for taking the leave or asking for the leave. New York State has a new paid sick leave law, but as of now, it's very narrow in that it only applies if you've tested positive or if you're symptomatic and you've had contact with somebody who tested positive. I think this is the sort of thing that we're likely to, hopefully, and as it does seem like there's more and more tests, fingers crossed, are to go around. As of today, I feel like this is a little bit meaningless to most of us. But I'm also thinking we may see more complaints on this, especially if, for example, you've had contact with someone who's tested positive. You've had contact with someone who had contact with someone who tested positive. Right now, this wouldn't necessarily apply to you. So the New York State paid sick leave, gives you a combination of benefits that add up to basically your full salary up to about in the range of about 100,000, and that's the New York State benefits, which are issued through the state workers' comp system, and this new temporary disability insurance. Don't forget to check your own contract or handbook because all of this stuff is supposed to be on top of that. These new laws go into effect tomorrow. Originally, it was April 2nd. They pushed it back a day to April 1st. That's the federal law, sorry. But you can't be required to exhaust whatever benefits you already have. So don't forget to check your own employment handbook, your own employment contract, your offer letter. And one thing I should have put on here is if you're in a union, well, I guess that's your contract, but if you're in a union, be extra sure to check your union contract, because in that case, most likely, unless there's something in the contract, none of this stuff is a reason why the employer would be allowed to disregard your contract. All right. Okay, if you're a caregiver, and I couldn't resist, this is our daily schedule created by my 5-year-old. What we're gonna do at school and work by Sadia. Sadia learn, Zora school, mommy work, Baba work, I love you. What we're gonna do at school and work. I thought you guys might appreciate this because a lot of us are in the same boat, just kind of figuring out how to deal with all of this stuff. Okay, it's not all roses, but that little drawing certainly is. Okay, if you're a caregiver, if your family member tested positive, I wrote congratulations. That's supposed to be tongue-in-cheek / sarcasm. You get the new state law. So regular PFL plus new TDI up to your full salary up to, it amounts to about 100K. If your family member has a major health condition, then you can still get the benefit of New York State's regular paid family leave. And this is, COVID is considered a major health condition according to the website. But I'm not sure exactly how this is going to work because, of course, lots of people who test positive don't experience major symptoms. And the test for a major health condition is very fact specific, but it's, it's basically like they're incapacitated and they need you to take care of them. So I think you need to, well, call us when you have questions or call a Better Balance with the Gender Equality Law Center. But the gist of it is that if you are finding yourself having to take time off from work because you have a family member who you're taking care of, tell your employer and they can help you apply for all this stuff. With PFL, you can go onto the website, you get the form online, so your employer helps you fill it out, it goes through your insurance. And the regular PFL now in 2020 is up to 10 weeks with a maximum of around $840 per week, and which adds up to, I think, a salary in the 60s. But please don't rely on any of my math because you know the joke about lawyers, or maybe you don't. We suck at math. Okay, taking care of your kids because their school is closed does fall within the EPSLA, which was one of the federal laws that we talked about in the last slide, and also the New York City law, the New York City paid sick law. So that, if you remember, is 5 days. So you can always get those 5 days. But what I wrote on here is consider furlough. If you're having trouble fulfilling your workplace obligations, and your employer is having trouble making ends meet, although now there's some really awesome grants available for small businesses. But you may want to talk to them about going on a temporary furlough, and then you can go and get unemployment benefits that your employer doesn't have to pay for. I mean, there's the premiums, but that's too much in the weeds. Just talk to them. They might say, yes, that would be awesome, and I'll see you after all of this craziness is over. It's always worth asking. And it may be that, the unemployment benefits with the new $600 a week, it's a big difference, more than double what you could get previously. Okay. If you or a loved one is immunocompromised, if you yourself are immunocompromised, I think there's a reasonable argument to be made that you can seek temporary leave time or staying at home as a reasonable accommodation. But that only works for yourself, as far as we can understand. And to me, this is a real gap in the laws. So I'm like, need to think creatively. Call us. We like thinking creatively. We like advancing creative legal theories. If you are in a situation where you or a loved one is still having to physically go into work, that falls under the situation that we are happy and honored to be able to provide pro bono legal services for. So just call us, reach out. I wrote, use the power of the letterhead. This is a term that I just made up. But basically, as we've seen over and over again, getting a letter from a lawyer is a million times more powerful than getting a letter or an email or anything from yourself. Once it's on our letterhead, we will get a very different response than you would get. We write to them. Suddenly, if you have a lawyer involved, it means they have to get their lawyers involved. Now the lawyers are talking. You're way better off. And of course, employers can't retaliate against you for asserting your legal rights under most of the laws we're talking about. So a lot of people think, oh, if I get a lawyer involved, my job might be more at risk. It is the opposite. Of course, I can never make any guarantees, but the truth is, with a lawyer involved, your job is more protected. And we have had plenty of cases where somebody was on the verge of getting fired and we showed up, and it's like now the employer is way more reticent to fire the person. So I just want to let you know we're available. It's free. I'm not trying to sell you on anything. So brainstorm constructive discharge theory. I'm sort of just using my creative juices to try to think about how you can keep yourself safe while also staying afloat. And the new expanded unemployment benefits are such a lifeline. Constructive discharge is a legal theory that means basically the employer made your working conditions, or whoever's fault it is, that your working conditions are, for whatever reason, intolerable. to the point where you, though they you, wow, that's a run. Well, hopefully I'll be back. There I am. Sorry, guys. Constructive discharge means it's as though if you're as good as fired because you can't work there anymore. We usually see this in the harassment context, for example, where in the hostile work environment context, if you're suffering from somebody who's mistreating you and it's causing you a lot of agita to the point where going into work is threatening to your mental health or safety. And I think we could apply that in these situations where, for example, we're all hearing about big companies who are, preventing people from wearing gloves or masks because they don't want to scare off customers. Like, I'll totally come in with guns blazing and send them a mean letter for you. I would love to do that. I'm getting a lot of questions here and there. Are we going to be able to watch this later? Are we going to have access to the slides? The answer is yes. We will send you a link that has this recording. We'll send you the slides. We'll send you links to our website that has all of the information. So yes, all of this information is not going anywhere. In terms of your constructive discharge, just to make sure that you're not giving the employer an avenue to claim that you've quit voluntarily, and don't, go be like, fuck you, you assholes, because if you engage in gross misconduct, then you're not eligible for unemployment. And same with quitting voluntarily. If your workplace is dangerous, this kind of bleeds into the earlier slide, and maybe they should have been one same slide. But OSHA is the Federal Occupational Safety and Hazard. I don't know what it means, but it's the employer's responsibility to provide the workplace that is safe and free of known hazards. And so I think that's a tool that we could use here in terms of the mask and glove situation. I wrote New York and federal whistleblower laws may apply here for once. That's because our whistleblower laws suck. New York State whistleblower laws in particular, because there has to be, usually for them to apply, some sort of threat to the general public safety. And so, hooray, threat to the public safety. I think anything involving, COVID and the quarantine and PPE, of course, this is a public safety issue. Employers can't retaliate against you for threatening to report any safety hazards, but in general, there has to be an actual violation of the law. So far, I think most of the guidelines are just guidelines when it comes to CDC recommendations and safety, but who knows? I mean, we could see new laws being passed tomorrow. So this is one of the many places where I think everybody needs to stay tuned. I'm going to stay tuned. I'll keep you in the loop. You also have to usually you have to give them an opportunity to fix, but there's an exception. Let me just find the language. There's an exception where the violation creates and presents a substantial and specific danger to the public health or safety. That's for the New York State law. I wrote just call us because every situation is so different. I'm trying to stay out of the weeds. And that means that, I really don't want you to use everything I'm saying as legal advice for your own specific situation. This is meant to be a broad overview, but call us. We're really happy to help you. Okay, what to do if you're being discriminated against? That is Blondie saying, call me. Please call us if you're being discriminated against. This is our area of focus. I'm not allowed to say specialty or expertise under the ethics laws. So I will just say this is our area of focus. It's what we do every day. I quoted here, this is one of my favorite quotes. If you've seen me present before, you've probably heard me quote this. So apologies for being repetitive, but I find this really powerful. And that is, in the city of New York, with its great cosmopolitan population, there is no greater danger to the health, morals, safety, and welfare of the city and its inhabitants than the existence of groups prejudiced against one another and antagonistic to each other. This covers, I listed out here all of the various categories that are covered under New York City's anti-discrimination law, with my apologies to those who are outside the city. If you're in the city, take a look at this list. It's very robust. It's much stronger and broader than maybe anywhere else in the country. And so in these times, you know, a lot of our Asian American friends and family members are suffering much worse than usual. And if you go to our website, there are places where you can report hate speech, where you can report discrimination. And so please keep an eye out. We really have to all look out for each other at this time. But I would say, you know, a special word of solidarity and support to our Asian American friends and community members right now. If New York City human rights law applies to any workplace with 4 or more employees, but you know, just call us if you think you're being discriminated against. We're happy to help. Yes, and as an aside, employers, we suspect slash fear that employers may use the COVID layoffs as an excuse, as cover for behaving in a discriminatory manner. So if you have any suspicions, a lot of times the key to building a discrimination case is talking to your coworkers. We always tell people there's strength in numbers. So just be sure you're talking to each other, form alliances, form friendships. That's something I always recommend, not only for the sake of your case and for building information, but in general for solidarity, support. We need to all lean on each other and rely on each other, especially right now, but always. All right, super quick for business owners. Sorry, I need to take a quick sip of water. There's a lot of resources right now for business owners specifically, and it really is deserving of its own presentation, which is why we decided to add a new webinar. Oh, okay, it's on the slide. By popular demand, we're doing a small business one Friday, 2 p.m. The key takeaways right now, obviously the flip side of all of the sick leave and the employment laws that have passed. But the main thing that business owners want to know right now is, how can I stay afloat? How can I keep paying my employees, or at least the good ones, which I think anyone attending my webinar likely is. New York City has a grant for small businesses with 1 to 4 employees, payroll grant up to $27K to cover 40% of payroll for 2 months. New York City also has zero interest loans up to $75,000 for any companies with fewer than 100 employees. You have to certify that you've seen a decrease in your business associated with COVID. So we'll get into that more on the Friday one, all of these. SBA also loans available up to $2 million. Those are the interest rates I posted here: 3.75% for businesses, 2.75% for nonprofits, and that's up to a 30-year term. And then the biggest one for me and for a lot of us, Paycheck Protection Program. And that's up to 2.5 months of your average payroll over the last year as a forgivable loan. This is a huge lifeline for a lot of business owners, and honestly, it's what is enabling us right now to devote our resources to doing all of this pro bono work, is that we don't have to worry about immediate cash flow, which otherwise would have been a big concern for a lot of us. So hooray, something actually useful from our federal government. That's not to downplay the other stuff they've been doing. You know, it's better than I expected. Okay, I wanted to just include a few pieces of miscellaneous helpful information. I don't know if anyone else out there is crushing on Cuomo. I feel like we as a society just agreed on this collective moment of levity that we all need, but I'm loving it. Okay, these are just sort of some key pieces for everyone to be aware of. This is for New York. There's a 90-day moratorium on evictions. I think, I mean, today was the day I think that we were hoping that there would be a rent freeze passed. For all I know, that's happened since we started this. But the courts are basically closed. They're not accepting any new filings. That's not to say that rent won't be due later. But for now, everyone keep your fingers crossed. But the good news is there's a little bit of flexibility on your timing, at least as regards the court process. Cuomo also issued an order saying no utilities cutoffs. So, you know, everything we can get right here. Remote notarization. I put that in because a lot of people are like, oh shit, I never got my wills together. I never got my healthcare proxy stuff in order. And a lot of people are doing that right now. You can do that remotely. Somebody I know was in a situation where I told them, like, no, you don't have to physically go somewhere to get this done. You can do this all by video. I would imagine this is the sort of change that will become permanent, which is, you know, one tiny silver lining to this whole thing. You can withdraw money from your 401k without the usual penalties. Something else to keep in mind. Free mental health resources. I'm really advocating this for everybody. Cuomo started a new free hotline that I know a lot of people, including people I know, I'm super proud to say, are volunteering for. So it's on our website, the phone number and the website and all the information. But please don't neglect your mental health. I know it's still a little bit taboo to talk about, but it's incredibly important. And in these times, you cannot afford to neglect it. So please go to our website. We have a lot of links about mental health resources. We have a lot of resources for domestic violence victims as well, which sadly is another big problem, always, but especially now. State courts are not accepting non-emergency filings right now, just something to be aware of. The court system is pretty much on hold. It looks like they may start operating remotely. And we have links on our website too, where you can just get updates from the court system and the Trial Lawyers Academy and all these other places that are way more on top of that than me. I just click around periodically and check out the news from them. And my last, for now, piece of miscellaneous helpful information is that you can have a partner with giving birth. This is something that came up in light of the coronavirus. A lot of hospitals were prohibiting partners, and I know there was a period where people giving birth in New York City hospitals were forced to do so without a partner present. Cuomo issued an executive order clarifying that hospitals are required to admit your partner with you. This isn't at this moment our main practice area, but if you are afraid, if you're about to give birth and you are hearing any rumblings or having concerns about the hospital, I would also be more than happy to send something on your behalf to the hospital, just going like this and saying, you know, we're going to come after you if you don't do this right, so get it together. So just keep that in mind too. All right, keep in touch. We are here to help. Well, my only favor that I'm going to ask of you is that you watch my amazing intro video to my law firm that's on our website. It features my daughter talking smack about Donald Trump. But also go on there to peruse our COVID Resource Center. You can see on this slide, crumiller.com/COVID. You can also email us, covid@crumiller.com. We set up a little email distribution list. So we have a team that will all get these emails to avoid any delays because a lot of these issues are so fast moving. So please don't hesitate to reach out. I hope you also stay in touch with us by liking us and following us on Facebook, Instagram, and Twitter. Sign up for our newsletter, tell your friends, email us with any questions, and also please do tell any of your first responder friends that we're offering pro bono services. We are all in this together. As we've been joking in our law firm, it's like we're all in this together, ... separately. But the point is, we're all here in the same boat. We're all facing the same struggles. And I am happy and honored to be in a position where, I'm able to contribute. And I would like to do that to the extent I can. So we are here to help. We're here as a resource. So that's it. Thank you. Well, that's it for the slideshow. I'm going to turn to the questions now. This is the first, I've been a guest on other webinars, but I've never hosted a webinar. So I hope I can figure out how to do this. How fast for forgivable loan? I don't want to get too much into the small business questions, like most here employee rights, but the answer is I don't know, because we don't know. We're waiting for guidance. The application for the payroll protection loan, it's going to be through banks. So you should check in with your banker, like go to your bank website, but applications aren't open yet. The banks are still waiting for guidance. The last I heard was that applications should be open early next week, I believe, maybe even sooner. If your CPA and or bookkeeper is not sending you lots of great updates and information, then I would say get a new one. Mine are amazing. They've been keeping me super safe. Don't miss anything. So we'll get into that more on Friday. Okay, let me see if I can find the questions. Okay, are certain protections? Are there protections for essential workers, service industry who are returning to work but do not feel safe doing so? Okay, this is a complicated question and also reminds me of something I should have put slide, which is that a lot of the new laws have exceptions for healthcare and emergency responders. So, I mean, the answer is sort of no. Lots of people are sort of frantically looking into these issues and waiting for guidance on issues. I think if you're being, it's situations where it's tough because the hospitals are under resourced. And so, from a societal perspective, you want to keep healthcare workers safe, but you also want them working. So there's no good answer. There's really, really no good answer. Most of these protections, as I said, don't apply. If you have an immunocompromised situation, you may be entitled to protection under ADA. But service industry, I mean, it depends. I think if your employer is being necessarily unsafe, I think you have grounds to argue some sort of a constructive discharge theory. Otherwise, I think the protection is just gun employment. I've been constructively discharged. I'm going on unemployment. If you let us, you're more likely, I think, to come back to still have a job. But I'm sorry, there's no good at that. Are there certain protections for New York City employees in the case of furlough? Since WARN doesn't apply, is there some notice that needs to be given? The WARN Act arguably does still apply. We're waiting for more guidance on that issue. The answer is not really. There's not really any sort of notice requirement that needs to be given. Even under the WARN Act, there are exceptions for unforeseeable circumstances. I think most likely those are going to be considered to apply in this case. Can PTO be used before being put on furlough? In general, PTO, if you have a book that says that PTO must be paid out at the time your employment is terminated, then it does need to be paid out. But otherwise, the default is not that it needs to be paid out. Unless there's something specifically saying it needs to be paid out, doesn't need to be paid out. So that's the sort of thing that you would need to talk to your employer and negotiate. And you can call us and we'll help. Okay, I'm currently a full-time employee for a small firm. Prior to that, I was running my own corporation, which still operates at a loss. Am I eligible for unemployment benefits if I'm still the president of my corporation? I don't know. I have a colleague who's go to nitty-gritty unemployment insurance questions. Oh crap. Okay, I hope you can still hear me. I'm gonna see if he'll be a guest on a future webinar. That's more specific than I personally know about unemployment. I was supposed to begin a temporary job at a preschool the day schools were closed. Am I eligible for entitled to unemployment benefits? I'm not sure. I think so. It depends on your past employment history, but I think everyone should just go ahead and apply because we're going to be getting more and more guidance about the expanded benefits. And from what I can tell, is expanded unemployment benefits really are sort of the primary vehicle by which we're getting help through the government, the state government. Of course, we have the one-time checks, which I show them misleading info, but I think you all know about that because everyone's talking a ton about it. How like pathetic and stupid one-time payment is, especially in New York City of $1,200. That's not going to help us at all. But you know, it's still money's money, but it's a drop in the bucket compared to the options that are available under the new expanded unemployment. Yes, something to remember that you do get your unemployment benefits as your employer affirmatively steps up to challenge your eligibility. And so a lot of times they don't bother. So it's always worth applying, always worth applying. I don't live or work in New York. Should I still seek your advice? I live in Maryland and Worthy. You can always reach out to us. We have friends all over the country who do some work. So if you reach out to us, we'll put you in touch with whoever needs whoever, you know, we think will be great to help you. No, I would not want to advise you personally, but I would be happy to put you in touch with somebody who can. And places like A Better Balance and the Gender Equality Law Center are, you know, they're operating hotlines with more robust advice and information too. So just reach out to us if you have questions. We're happy to either answer ourselves, point you in the right direction. You know, we'll make sure that we help you along, whatever that means. Okay, there is a line in the CARES Act passed this Friday that states a covered individual for unemployment is one who has to quit his or her job as a direct result of COVID-19. Would that cover someone who voluntarily quit their job because they felt unsafe and concerned about contracting COVID-19 due to age or other conditions? I think this is sort of what I was talking earlier about the constructive discharge theory. I think if you just feel unsafe and you're concerned in general about contracting COVID-19, I don't know that that is necessarily going to be enough to overcome the usual requirement that you're not entitled to unemployment if you voluntarily quit. So I think this is just one of those places where we need to thread the needle. And I also think my hope is that more guidance comes out. As of today, when I checked, I didn't see any guidance around that particular issue. But they're putting out guidance very regularly. Everyone has the same, you know, we all have the same questions. If a payroll cycle is on the 15th of each month and the 31st of each month, and employees were laid off on the 20th but paid through the 31st, can they receive unemployment since they were, can they receive unemployment for the week of the 23rd to 29th since they were officially laid off by the 20th but pay through the 31st? That's a great question. That's one of the ones that I'm going to look there's a few things that I'm gonna try. Like, I don't know. I'm gonna try and figure it out, and we'll be sending all of the attendees an email with the link, so you can watch this, link to our website, and that's one of the things that I want to see if I can answer, because I think there are people who know, and I just don't off the top of my head. Okay. Someone made a comment. Okay, I work at a federally qualified health center, and while we are unionized with 1199 SEIU, I'm on the union bargaining committee where I'm still bargaining for our first contract. Of course, our employer is using COVID-19 as an excuse to cut off contract negotiations and have ignored our request to discuss current working conditions and management's response to COVID-19. The union has made complaints to the Department of Health and Mental Hygiene, and I've encouraged my coworkers to file their complaints through, and here's a link. Yes, that's a great a link to the Department of Health and Mental Hygiene. If we don't have that link on our website already, I'm going to make sure we add it on there, because I agree. It's a good place to file complaints. Here's the problem with employers behaving badly, and this is just true in general, being an employment discrimination attorney or any kind of an attorney, is that people come to us a lot. They say, okay, my employer is doing X, Y, and Z. Is this legal? The answer is, it doesn't really matter a lot of times, because there's no magical, like, there's no God from heaven who descends and say, ta-da, what you're doing is illegal and you need to stop it immediately. The only way to get a determination over what's legal or illegal is to go through a lengthy process of litigation or filing an administrative complaint, and ultimately you get some sort of a result. And by the time that all happens, it's way too late. And so I always sort of try and think about, are there like tracks that we can take? On one hand, we need to figure out what can we do immediately to address whatever the situation is, with the understanding that if your employer is behaving illegally, we don't necessarily have a super urgent, immediate way to stop them. The best that we can do is use what I've termed the power of the letterhead. When we send a letter and we say, we're going to get you down the road, or we're after you. Sometimes employers will change their behavior right away, but it's good to just be cognizant that, for example, filing complaints with the Department of Health and Mental Hygiene, I encourage it. I'm not trying to discourage it. I think it's a good idea, but just keep it in mind that you may not get any sort of an immediate relief as a result of the complaint. Okay, somebody wrote no rent freeze yet. Yes, so a lot of people joining late, joining throughout this webinar. We're going to distribute the recording. We're going to distribute all of this information. And yeah, so yes, the recording will be available and the slideshow will be available too. It's so funny. There's one last piece of like miscellaneous helpful information that I thought of like 5 minutes before this started, that maybe I'll just retroactively add to that slide. I learned yesterday from Twitter that in Zoom, when you send a private message to somebody else, other people can't see it during the conference, but they can see it later when the video and the chat transcripts are downloaded. So it's like alert, alert, don't private messages unless you want everyone to read them. Okay. That like caused a bit of panic when I heard about that. I was like, oh crap, I could myself making that mistake. I'm gonna go for 4 more minutes of questions. So if anybody has more questions, now's the time. Okay. Is the extra 600 automatic, or do you need up to 500? Yes, up to 500 income, and then the extra 600 does not depend on your income. It's the same. It's one application. You go and apply. Now, I have to warn you that the systems are super, super overloaded. They set up a system where different days of the week are for different, it's like the first letter of your last name, but it's been really hard to get through. I know lots of people who have just been trying to get through to the website and it's frozen and it's not letting them through. There's a number one call. So I know someone, I'll find out what happened, but she was logging on. I guess they open at 7:30 a.m. So she was like trying to click on at exactly 7:30 a.m. to be the first one online. So just keep that you might have to develop some persistence and apply it to your application process. Okay, sorry. The enhanced unemployment, does that mean you can receive a maximum of about 1,100 a week for the first 16 weeks, then the remaining 23 weeks you can receive approximately? Yes. Wrote, all of the phone lines were busy all day and the site crashes all day. That's what we've heard too. I don't have any good answer for that. Okay. My employer is continuing policy of every paid sick and PTO accruals, forcing people to FEMLA, as a kinds of COVID-19. Qualify for PFL to being symptomatic, being ordered into isolation at home by my PCP, and coming into close contact with someone diagnosed with COVID-19. I informed them in an email that not notifying work with PFL and their continued application of their policy is illegal under New York State law. I also notified them that I had also already filed a PFL claim with their insurance. 2 days later, they sent me PFL paperwork without responding directly to my email. My coworkers are still being required to exhaust their PTO and sick leave accruals without being provided with any additional sick leave. I mean, this is a very classic situation. I think this is one of those crappy things. The classical whistleblower law would not apply. And so I think you need to be careful of those things where the right thing to do is to clearly tell all of your workers. And, you know, I think you've done everything right in terms of asserting in a way that gets them to comply. And just, you know, keep at it and or tell your coworkers. If you get a letter, we're happy to. But, you know, I think it's always a balance between looking out for yourself and look for your colleagues. And that's like out of my grade, figuring out how to advise in that respect. If your landlord is mortgage relief, can you automatically get rent relief, personal and commercial? How would you know? So right now, answer is no. Right now, there's no relief. Who knows what will happen the rest of the day, because tomorrow's the 1st and most people rent is due. But we just have to keep an eye out and see if that happens. Right now, it hasn't happened. So there's no rent relief other than just to note that there's the moratorium on evictions. And there's also the temporary court closings where they're not accepting any non-merge filings. All right, everybody. I'm going to wrap this up. Thank you so much for joining.